now in session. All those who cause to plead, draw the line, give attention, and you shall be heard. And God save these United States, the great state of Florida, this all. Please be seated. We have two cases on the docket this afternoon. We'll take them in the order that they appear. First is Mack versus Perri. Are both sides ready?
Helen's ready, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the Court. Good afternoon. My name is Todd Leducer, and I represent the Macks. If I could reserve 3 minutes for rebuttal, ma'am.
Okay, I will try to remind you, but you have the clock in front of you.
Thank you, Judge. We're here on an order from the lower court that dismissed the appellant's claims in an estate based on untimeliness. The timeline becomes important, so I want to just go over a couple of things as we did. Dr. Watts was a doctor in the Pensacola area. He died in November of 2004. The estate was open. Personal representative was appointed in May of 2005. The first notice to creditors, which is required to be filed in a local newspaper, was filed on May 14th, 2005. That ran on May 14th and May 21st. Then 3 months later, for reasons that were not explained down below or any reason was given whatsoever, there was a second notice to creditors filed in that same newspaper in August of 2005, August 6th. It ran on August 6th and August 13th. My clients filed a statement of claim in that estate on November 2nd, 2005. My clients have an unliquidated and pending medical negligence case against the doctor. Still unliquidated, have no idea what it's worth, if anything, at this point. It's stayed pending this.
Counsel,
Yes,
why is the later publication relevant when the statute clearly runs from the time of the, quote, first publication of the notice?
Two reasons. There's an ancient, not ancient, 1957 Florida Supreme Court case, Williamson, that the court relied on below, that talks about this situation when there's two notices sent. That court said that it was a nullity. A legal nullity doesn't mean anything. However, in 1965, this court basically reviewed that Supreme Court case and said, well, look, when you're filing this second notice, it doesn't necessarily act as a bar if there is good cause to be shown. The Meigs case, M-E-I-G-S, from this court, years later after that one, said that there's a good cause exception if there's a second notice filed. So from this point, I say that there's precedent from this very court that says that if the good cause is shown, that second notice might be the operative notice. Moreover, if the first notice is defective in any way, let's say, for example, it doesn't say what it's supposed to say, it doesn't read what it's supposed to read. If that is defective in any way, then that is not even really the first proper notice that was published. The second notice could be the first properly published notice. And in this particular case, the underlying court didn't make a ruling on that, but the differences in the record, there are differences to the two notices. The dates that they run are in different locations on the notice. Moreover, in the lower court, the only one that was paid for by the estate was the second notice. They had no explanation as to why it was filed, yet it was the only one that was paid. We were not allowed to present any evidence as to good cause in the lower court because the court ruled that, hey, look, it doesn't matter. It's a legal nullity. It doesn't matter at all. However, based on this court...
Was there anything defective, though, in the first notice? It probably gave notice to the creditors, didn't it?
Well, again, that is a statutory required notice that has to be in the exact form or else it is not proper. And my argument with that is that there are differences between the two. Moreover, evidence that why would you file a second one anyway? The first one was defective. Why was it defective? For whatever reason, you didn't pay for the first one either. The newspaper didn't just publish this out of the goodness of its heart. It got paid to publish the second one. That was the only one that the estate paid for. So at least from my perspective, the estate...
Why should it matter whether it's paid for?
Because, yeah, I understand, Your Honor. Because that is evidence that the estate felt that the first one was defective in some way. Therefore, it did not pay for the services of the newspaper. It required a second one and then paid for the second one.
Would it matter if the state thought it was defective? Can't we look at it and say whether it's defective or not?
I think you can, absolutely. And again, I think the lower court...
But I don't understand why it would be relevant. I mean, it seems to me it's the legal question. Whether the state thought it was defective or not, if it was an appropriate notice.
Here's why. On 733-702 requires a claim to be filed within 3 months or within 30 days after notice if you are an ascertainable creditor, to where you're one of these people who's supposed to get notice individually. November 2nd, 2005 is within 3 months of the second notice. It is not within 3 months of the first notice. So the first determination that has to be made is which is the proper notice to be given legal effect in this case, because as these arguments
I
cascade.
understand that, but what would it matter to the subjective feelings of the estate? I don't understand that.
That goes to the
Seems like an
good.
objective question whether the notice was proper or not. So why do I care whether they thought it was defective or not?
Well, again, that would go to the good cause argument that I was precluded from making back then. They were allowed to present evidence as to why there was a second notice. The evidence was, I don't know, we didn't pay for it, I'm not sure what happened. That was only the evidence presented by the paralegal of the office. It wasn't the lawyer who was listed in that. I was precluded from presenting any evidence on that. What I'm trying to suggest is I should be allowed to show that evidence for good cause if, in fact, it's defective, and they thought it was defective. I should be able to bring that to the court's attention so the court could then say, lower court, hey, I think there's a good cause exception under Meigs, therefore we're going to make the second one operative. Or I can rule that the first one was not defective. That ruling is not there. What's there is it just says that the first one controls regardless of what happens afterwards. There's not a ruling that it was not defective, or there's not a ruling that it was not different. There's not that ruling below. My argument with there is that at the very least I should be allowed to present some evidence to show a good cause exception for that reason. Because if it was 3 months behind it doesn't matter. But where this falls factually is, if that's true, and the second notice is either the first operative notice or the controlling notice, 3 months is met, we don't have to talk about anything else.
So with regard to the first advertisement, did you argue below that it was defective?
Yes, sir.
Okay.
And we argued below, and I tried to put on evidence about good cause. The court did not allow me to put on any evidence whatsoever with regard to that.
Unless you can actually show a defect in the notice, I don't understand what evidence you wanted to put on. I mean,
I think there's a
it
difference
seems
in
to me
the
that you look at the notice and say, is this notice sufficient, does it sufficiently comply with the statute? And if it does, then I'm not sure I understand your argument as to what you wanted to present.
Well, again, there are differences in that. It is not an identical copy of the first. There's differences in it. Where the dates show on that stuff, and it's actually technically, you look in the records.
Whether or not there are differences, what
Yes.
is defective about the first notice?
Well, I'm not positive that it was.
And what did you present to the trial court
Well,
as far as it being defective?
Well, again,
you
it was not.
You didn't need to take evidence. You just look at the piece of paper and either you made argument or you had the chance to make argument.
Well, again, I don't know that I was given the chance to make that argument in there about this because the court went on for other things. But again, the reason that I'm saying it's defective is that there's at least and again, we have to look at it, is my argument is that one of the dates, the second date in which the first one was supposedly published, is not in the same location that you would expect it in that paper for a publication, which gives me pause that it was not published on that second date. That was 4 years ago, and I did not have a copy of that paper 4 years ago to do that, Stan. But where that second date for the second date of publication is listed on the notice is different than the second one, which shows where it was. And I'm positive that the second one was published twice. So for that, I think that's important because of where it falls in there. Moreover, even if the first one is operative, there's good cause for an extension as to when there are two notices here. Was not allowed to do that. That argument is made because it matters for the
quote you have in your brief from the Meigs case.
Yes, sir.
Talks about is the decision in that case does not operate to preclude the granting of an extension of time upon a showing of good cause. But you could always have filed a motion for an extension of time, could you not?
Yes, sir. And that's my secondary argument. That's my second argument, and we're getting to that. But Meigs is more appropriate with the Williamson argument about two notices. That's the point there, that you've got this good cause with two notices. You also have the exception that happens after Pope when we change our statutes in the Florida legislature to comply with the U.S. Supreme Court case in Pope that said that, hey, there are a certain level of creditors that must get notice. If they're reasonably ascertainable, you've now got to send them notice, and they get 30 days from that individual notice to file a claim. That grafted onto 702 the following. I'm sorry, 702, that any claim not timely filed as provided in this section is barred, even though no objection to the claim is filed, unless the court extends the time in which the claim may be filed An extension may be granted only upon grounds of fraud, estoppel, or insufficient notice. All right? That's what it says. So that then grafts into there an exception that you missed the 3 months. You're within the 2 years that is an absolute bar to claims. Now you have an opportunity to get an extension. What this statute does not say is when that extension has to be granted, when that petition has to be filed for the extension, or when the court has to adjudicate that extension.
But is that an issue here? Because, as I read the record, you didn't file a motion for an extension, did you?
We did, Your Honor. Before the hearing that was held. Absolutely true.
After the 2-year period?
After a 2-year period, but before the hearing that was held on these motions in here.
But it's my understanding that the motion for an extension can be filed after the running of the 30-day period or the 3-month period, but it still has to be filed before the non-claim period.
That is not in any statute or in any case that I have found. There is that statement right there is the crux of what we're here about today about right now. That is not in the statute. It is not in the claims. It is not in the Mays case. It is not in any of these cases, because you could have this very situation. I file my claim at the 2-year mark, right at the 2-year point. Now, do I have to file my motion on that same day and have it adjudicated that very same day before the 2 years runs? It is the filing of the claim that stops the clock, not the adjudication of any possible extension qualifying that claim.
So your argument is that there is some sort of tolling of this 2-year non-claim provision by the filing of the claim?
No, sir. It is not told. You have filed the claim. This is the point. What is the definition of is? You have filed the claim. The claim is filed when you go down to the clerk's office and hand them a copy of your claim. Now, it is a mechanism of the court and its docket and whatever else it has to adjudicate whether an extension should be done. As long as that is filed before the end of the 2-year period, or within 30 days if you're a reasonably ascertainable creditor, as long as that is filed within that period of time, there is no time limit in the rules, in the statutes, or in the cases that mandates that must be adjudicated or even filed before the 2-year claim. I look to the Mays case here on this. It says clearly 733 creates a self-executing absolute immunity to claims filed for the first time more than 2 years after the probate. We do not have that case here. We have it filed within the 2-year period, even if we disregard the second notice. We have it filed within that period. We just do not have it adjudicated within that 2-year period. So, again, that is not there. It is first filed. Moreover, even in the Mays case, if you look at the very end of it, and this is post-verdict or post-adjudication in May, it even talks about we are not aware of any extension or pending request for an extension in any probate court. This case was filed, it was years after the 2-year period ended, and the Supreme Court of Florida is still saying we're not aware of a pending request for this. So there could have been a
pending request for extensions, though.
Yes, sir. Request for extension. That's right. In that case, it was filed within the period, but my point is, if you file it within the 2-year period, you're filed.
The extension was filed within the request for extension, though, in that case was filed within the 2-year period.
It does not say that. It does not say that in the case. Does not say that in the case.
So you're down to about 2 minutes.
I understand. And unless there's further questions, I'll remain my other time for rebuttal. Thank you.
Good afternoon, Your Honors. My name is Daniel Perri. I'm an attorney for the estate of George Watts, the appellee. First of all, regarding the May case, I do want to say specifically that it considers the 2-year statute under 733-710 to be an absolute statute of repose. And if I may briefly read from page 1157 of the May decision, it states that Section 733-710 operates as a statute of non-claim or statute of repose because Section 733-702-5 expressly prohibits any court from granting an extension of the time to file a claim against the decedent's estate on any grounds, including fraud, estoppel, or insufficient notice of the claim beyond the 2 years following the death of the decedent. The decedent died November 2004. 2-year period would have been up in November of 2006. The first time the insufficient notice defense or claim was raised by the appellate was in February of 2009, 4 years, 3 months from the date of death. The claim that was filed by the appellants was late.
What about the October or November 2005 claim that was filed?
That's what I'm talking about right now. The claim that was actually filed.
That was within the 2-year period.
Yes, it was, but it was late at that point in time.
Beyond the 3 months.
Beyond the 3 months. Therefore, under 702(3), it's barred automatically.
Subject to an extension.
Subject to the extension, which never happened. There was never a motion to extend based upon fraud, the estoppel, or insufficient notice at all.
If I understand the appellant's argument, it is that since the claim was filed within the 2-year period, they can file a motion for an extension of the 3-month deadline at any time. And did I understand you correctly that that is contrary to May?
That's contrary to May, page 1157. And then later in that same paragraph that I was reading from, it says the 702 provides for the basic filing. The 710 is an absolute bar. And the statutory scheme, Your Honors, was there's a 90-day period, a 3-month period the claim had to be filed in. It was not. It was late. It's barred by 702(3). The only way around that is he had to file a motion to extend based upon those 3 grounds of fraud, estoppel, or insufficient notice. It never happened until 4 years after date of death, 2 years past 710 requirement of 2 years from the date of death. And talking about 702, he indicated that there was nothing.
If a notice of claim is filed within the 2 years and gives grounds, and I understand it's not a request for extension specifically, but on its face demonstrates grounds for an extension, why shouldn't we treat it as an extension, request for extension?
There's nothing on its face. It was just a claim. It was a claim that was filed, and under 702(3), it's late, and therefore it's barred automatically. And so they're required to file a motion to extend. Otherwise, the claim is gone. And I also want to say that under 702, I believe when Judge Van Ork was asking the appellant's attorney a question about 702, he indicated there was nothing in 702 that indicated that there was the 2-year requirement. That was the drop dead date. But in 702(6), critical, it says, nothing in this section shall extend the limitations period set forth in 710. So that the 710 statute trumps 702, and in 710 itself it starts out, nothing in this section, nothing in this probate code shall overcome this. 2 years is the drop dead date.
But what about subsection 2 of 733-710 says this section shall not apply to a creditor who has filed a claim pursuant to 733-702 within 2 years after the person's death?
That's correct. Pursuant to 733-702. That means a valid claim, not an untimely claim. 702 requires that the claim be filed within the 3-month period, otherwise it's barred. Within 2 years, then that means that if it's late after 3 months, they would have had to file a motion for an extension between the end of the 3-month period and the end of the 2-year period. Otherwise, it's barred. Otherwise, the statute makes no sense. There has to be 702, 3-month period, you file your claim. If you're late, you get an extension based upon only those 3 grounds of fraud, estoppel, or insufficient notice. If you don't do that, by the end of the 2-year period, 710 comes into play, and it's an absolute bar. That's what May says, and that's what I read to you, that even including a potential valid claim for insufficient notice or fraud or estoppel, if the motion for extension is not made within that 2-year period from the date of death, it's barred.
What if I understand your position that it was not there. What if this claim had said, I received insufficient notice, or there was insufficient notice provided?
If the claim had said, it did not say that.
Okay. But if it had, could that be treated as an extension?
I don't think so, because I think the claim, if it was late, would still require a hearing before a judge that there was some estoppel or some insufficient notice or some fraud involved, that would convince the judge that there was, in an order to go ahead and allow a claim to be filed late, which did not happen here. There was never anything argued by the Macks, the appellants here, that would show anything within the 2 years. It was 4 years before we ever brought this up. And also, in the record, in response to the motion or petition to strike the claim as being late filed, in the record on page 98 and 99, they admit that the claim was late. It says, claimants were unaware of the possibility of a medical malpractice case and, as such, did not formally file their claims before the expiration of the time for filing. This was in December of 2005. The claimant's response states that even though we have filed a late claim, we still have the right to proceed against the malpractice insurance coverage of Dr. Watts. And then the last paragraph of that response, it says, the claimant's claims against the estate are limited to the amount of insurance coverage. Any excess, should that result from any verdict, would be barred. Now, that's my position. That's what I want to hear. When I saw this document, that's exactly what I thought was going to happen. There was no claim against the estate's assets, only against the claim against the insurance. To get to the estate's assets, he would have had to file the motion for extension, which he never did, in a timely basis under Section 710. Because we have 702, 3 months, 710, a drop dead. That's it. If you don't file, it's over. And otherwise, we could continue going on all the time. And in the interest of preventing stale claims and expeditious handling of the states and meeting the Pope requirements in the U.S. Supreme Court, the statutes were changed to meet the Pope requirements. And 710 is the statute of repose. It has to be. That's the way, I mean, that was the intention, and that's the way May interpreted it. So, again, I want to repeat, that on page 1157, 733, 702, expressly prohibits any court from granting an extension of time to file a claim against the estate on any grounds, including fraud, estoppel, or insufficient notice, beyond the 2 years following the death of a decedent. We find that 733, 710 is a statute of non-claim that automatically bars untimely claims and is not subject to waiver or extension in the probate proceedings. Any other questions?
The appellant argues that the trial court erred by precluding the appellants from making what they call a good cause showing with respect to the date of applicable date of publication.
Yes, Your Honor.
Why isn't that a good argument? Respond.
Because when the claim was filed in November of 2005, within 2 weeks there was an objection to it as being late. In their response, the December 2000 response, which is in the record at 98 and 99, they didn't raise any question, any issue regarding the first notice or the second notice. They state that they were late. And the only way they were late is relating to the first notice in May of 2005, not the one that occurred in August. I don't know what happened there anyway. It just that happened. But that first notice was what they're referring to in their response, saying we were late. They didn't raise the issue, one, that there was two notices, two, that there was insufficient notice under the Pope requirement of an ascertainable creditor or estoppel or fraud. None of those issues are raised in their response to the objection that their claim was late. So, and then they never filed anything for 2 years. So when we get to the final hearing in March of 2009, finally, 4 years later, 710 bars anything else. There is nothing to talk about. There was a late claim barred by 702.3. It's barred. There has to be an extension, and it has to be based upon the three grounds of either fraud, insufficient notice, or estoppel. Never happened. The 2 years go by under 710. It's barred. 2 more years later, we're finally arguing this point about insufficient notice. The judge said, time's up. 710 bars you. I don't have to take any evidence. You're barred. Okay. I understand. That's all I have. Thank you.
A couple of things.
Okay, where are you going? When was the first time that you brought the issue of insufficient notice to the attention of the trial court?
Prior to the hearing to adjudicate all of these motions.
Okay, and was that after the 2-year period?
It was after 2 years, yes, sir.
Okay, thank you.
The reason behind this is the 2 years is a statute of repose for what? Filing a claim, not adjudicating an extension, not doing anything. He is correct, but only partially. If I go to the courthouse and file a claim 2 years and 1 day after the date of the decedent, I am barred. Barred. No question about that. Statute of repose. I have first filed my claim 2 years and 1 day. I'm late. Absolutely true. I go to the courthouse 2 years from the date of death and file a claim. I'm within 2 years. I'm outside 3 months. I now have to have an extension adjudicated. I am not automatically barred at that point. And it is impossible, unless you file it, get it adjudicated that day, to meet what he
Why
says.
shouldn't you have to put the state on notice, though, that you are requesting an extension within that 2-year period?
Again, these statutes could say that. The case could say that. They don't. None of the statutes say that you are required to do that. Go back to when Pope changed the landscape. We've got 5.495, which was the formal rule that was employed before they amended the statute. That rule allowed 2 ways to get that extension adjudicated. A petition for an extension or a petition to require payment of claim. Which claim was filed after the time allowed for the law presenting claims. So you could file to get it paid at the end and say, hey, look, I want this claim paid. I'm entitled to an extension because I filed after 3 months but before 2 years. That was in the rules beforehand. I think that is exactly what we're talking about. Moreover, it's academic now. I don't even know if we have a claim. It's unliquidated. We haven't even tried the Med-Mal case yet.
Thank you.
Thank you, Judge.